Good afternoon, everybody. This is Grant Kaplan, or Grant Kaplan, from the law offices of Grant Kaplan, based in Boca Raton, Florida, United States. I want to talk to you today about various developments in immigration law and how you can take advantage of them. First of all, our contact number is +1 561 347 8440, and our email address is grant@gkaplanlaw.com. Again, grant@gkaplanlaw.com. If you're interested in looking us up, our website is american-immigration-lawyer.com. We run a full-service immigration law office in Boca Raton, Florida. We help clients throughout the United States and across the world. We've been in practice for 22 years, and we cover the full spectrum of immigration. Today, I want to discuss developments in immigration law by covering the various categories of immigration, such as there are presently and which are mostly utilized. There have been, through COVID, a downward spiral in the service that we could expect from the immigration service and, in fact, from the immigration courts and at the consulates. In fact, many consulates have closed through COVID. Staff were dismissed or terminated, and they've had to retrain staff in order to come again and offer the services that previously were available. This has resulted in a huge backlog at the consulates, some of which span a number of years. I want to go through a number of visa categories for you because, as you may know, there's only specified ways to come into the United States, and contrary to what some people believe, most people around the world want to come to the United States to live the American dream. So, the first basis to come in, or the first option that could come in, people could come, is through a family-based visa. And family-based means that you have a U.S. citizen or permanent resident relative. And eligible people as beneficiaries who could come in are parent, child, sibling, or spouse of a U.S. visa or a permanent resident. And the preferent categories depend upon whether they are immediate, as in the case of a parent of a U.S. citizen or a child under 21, or a spouse, as opposed to whether you're filing for a sibling, which could be more than 10 years. So processing times vary for each of these, and there is a visa bulletin every month under the USCIS website, which describes in detail how far immigration is in processing different visa categories. Also, there is a fiancé visa where U.S. citizens can file for fiancés overseas. We do many of these applications and, of course, would be happy to assist with each of these. In addition to that, we also, of course, do naturalization applications and green cards of all kinds, which we will discuss in some more detail as we go along. So again, if you want to contact us, +1 561 347 8440, and our email address, grant@gkaplanlaw.com. I am wearing my glasses for the occasion, so of course, in case you didn't recognize me before, there you go. All right, so that really deals with the family category. Now, it is possible to change your status in the United States. So if you, for example, want to adjust your status or change your status in the United States from one visa category to another, it is possible to do this provided you have been in the United States for at least 90 days in a lawful visa category. So let's say you come in on a tourist visa, for example, and then decide to get married or become a student. It is possible to change your status once you have come in and been in the United States with the intent of remaining in your initial visa category for the first 90 days. Of course, you can change your intent, and it is possible to marry, to become a student, to be employed, to open up your business, or whatever other visa category we'll talk about in some more detail as we go along. So again, if you're coming in with a visa, it is possible to change your visa status. If you're coming in with what is known as an ESTA, a visa waiver, then for most purposes it is not possible to change your status unless you're an immediate relative, being a parent, a child under 21, or a spouse, in which case it is still possible to change your status even though you've come in under a visa waiver after 90 days. Now, categories really matter, as I indicated to you. For siblings, for example, it might take longer than 10 years before the priority date is reached. And the priority date, incidentally, is the date upon which the Immigration Service will act upon your particular visa category. And that is, as I've mentioned earlier, contained in the visa bulletin. So again, spouses, kids under 21, parents of US citizens, typically on the first preference category. Something which is worthy to note is that if you marry a permanent resident, not a citizen, and you are in the United States in status, that visa category happens to be current at the moment. So a spouse can change or file to change their status in the United States, even though their spouse is not a U.S. citizen, but a permanent resident. Again, for any questions that you may have in regard to any of these things, please contact us, 561-347-8440, and email address grant@gkaplanlaw.com. Again, consulates have really been backlogged, but they are doing their very best to update and to get themselves in line as to where they were before COVID. And incidentally, we'll talk about COVID and vaccinations and so on as we go along. All right, let's move along. So we've discussed in brief family-based visas. We're now going on to employment-based visas. Now, there are 3 or 4 different ways that you could come in with an employment-based visa. The first is what is known as an H-1B visa, which is for professional employees. And you would need to have at least the equivalent of a U.S. bachelor's degree, and the employer needs to require someone who has at least that qualification. So if you have a foreign bachelor's degree or the experience equivalent to a bachelor's degree, we would get you evaluated through an accredited evaluation agency to have the equivalent of at least a U.S. bachelor's degree, and you would file together with the employer who needs to obtain the prevailing wage from the Department of Labor and offer that to you. H-1 visas are limited in number and limited in time. There is a cap, as they call it, and we need to file by March the 1st of this year for an effective start date of October the 1st. They only accept 65,000, and once that number has been exhausted, immigration will typically embark upon a lottery, a random computer-generated lottery, to determine who the 65,000 should be. If you hold at least the equivalent of a master's degree, there are an additional 20,000 that are available. So that's the H-1B visa category. So if anyone is in that category, I suggest you contact us immediately, as we do not have much time to prepare and file these applications for you. If you're going to be employed by a non-profit organization which has some kind of affiliation with an institution of higher learning, it is possible to file these at any time. Again, please contact us, 561-347-8440, and our email address, grant@gkaplanlaw.com. So that deals with the H-1 visa category. If you are a Canadian or Mexican, there is another visa category called a TN visa, which allows you to come in with the equivalent of a U.S. bachelor's degree and get a professional employee visa under certain visa categories with that in mind. If you're an Australian, there is an E3 visa which is available to you also, which is similar to an H-1 visa. For any of you guys that are in that position, please let me know, and we can certainly talk about that in some more detail. There are also seasonal worker visas which are available, called H-2B visas, If you're an agricultural worker, H-2A visas, which allow you to come in for at least 6 to 9 months at a time. Incidentally, there are other assorted visas, such as a B visa in lieu of an H1 visa, which would allow you to come in for a specific project, and you can certainly discuss those with us. Again, email address grant@gkaplanlaw.com. If you are going to be employed with a green card in mind, the employer can file for your green card at any point. And depending upon your qualifications and experience, that will determine the category under which you would be filing for your green card. If you're an exceptional person and you're a Nobel Prize winner, or you happen to have won international awards, for example, then you would fall under an EB1 category. If you have a master's degree or the equivalent, or you happen to be in the national interest, it is possible to file an EB2 visa in the NIW, the National Interest Waiver category. And we have done those for a number of pilots and for various others. So again, contact us, grant@gkaplanlaw.com, and we can discuss those. Typically, if you hold at least a bachelor's degree or the equivalent of a bachelor's degree in terms of your academic or experience is concerned, there's a PERM process, the labor certification process, which the employer has to embark upon. That process takes about 12 to 18 months to get a green card, and you can certainly file for the green card in conjunction with any other visa application, such as an H1 visa or any other visa, non-immigrant visa, even a student visa, if you wish to embark upon the green card on that way around. For the national interest waiver, incidentally, you do not need a sponsor and can file on your own. Whilst we're on the topic of exceptional people, I know everybody thinks that they're exceptional. I think I'm exceptional, but we have to have the immigration agree with us, and there are visas called O visas, which are for extraordinary people. So if you're a leader in your field, whether it might be in the sports field, academics, from a business point of view, or anything else, and you have a potential offer of employment in the United States, it is possible to file for an O visa. And we have done quite a number of these for golfers, even for a hairdresser, for some businessmen. So it is possible to talk about these if you believe that you are in that category. And again, contact us at grant@gkaplanlaw.com. All right, moving along in the business visa category, we deal with many business-related visas, the most common of which are called L1, intra-company transfer visas. These allow you, if you own or are a manager in a business which is at least 2 years old, and you have been employed in that business for at least the last 12 months, you may be eligible to set up a branch or subsidiary in the United States, or if the entity already has a branch or subsidiary in the United States, to be transferred from that entity into the United States. So we deal with many new entities that are set up in the United States. Of course, the business in your original country needs to continue operating, needs to be viable, and you need to continue operating in that country. You could be transferred across as an L1 intra-company transferee together with your family to come in and set up and operate the business in the United States. These form the main crux of our business, and we always have done 1 to 2 of these visas a week throughout. It's a great visa to have. There's no minimum capital investment required. You do need to come and set up the business in the United States. You do need to employ a couple of people over a period of time, and you do need to be at least a manager or executive in the business. Typically, for a new business, you'd be given 1 year to set up and operate. For an existing business, you'd be given an initial 3 years to set up and operate. Again, there's no minimum capital investment required, but you do need to show, of course, that you have at least sufficient funds to set up and operate the business and to continue conducting the business. As an L1 visa, after the period of 1 year has expired, typically you would be eligible, providing the U.S. entity is viable, to file for a green card for you and your family, and that process under what is called the EB1C process takes about 12 to 18 months to be approved. Once you've got your green card, of course, you don't need to maintain the nexus between the U.S. entity and the foreign entity. You can dissolve it or do whatever else it is that you need to do. Your spouse would also be given work authorization to work wherever he or she wishes, and kids under 21, of course, will accompany you and be able to go to school. So that is the L1 visa, a great visa option if you can make it work. Please contact us with any inquiries in that regard. My telephone number 561-347-8440 and email grant@gkaplanlaw.com. Moving along to other business-related visas, there are investor visas called E2 visas. These are for citizens of certain countries with whom the United States has a treaty in place, and citizens of those countries can invest a minimum of $100,000 in a business, either new or existing, or at least 50% of a business of at least $100,000. That would enable you, the investor, to come in, set up and operate the business in the United States. Your spouse also would be given work authorization. Again, kids could go to school. The only potential downside is that it is somewhat difficult directly through the E2 visa to get a green card. Many people, for various reasons, don't want a green card, but of course, it is possible indirectly through sponsorship of an employer or anyone else to get yourself a visa, a green card in that regard. And then finally, on the investment side, the EB5 visa, which is an investor visa. This is a great visa to have because it's a passive visa. You need to invest a minimum of $800,000, either directly or indirectly through what is known as a regional center. The funds need to sit with the regional center for a period of 5 years. And in the meantime, once the EB5 has been approved, that allows you and your family to get a green card. A new amendment to the regulations regarding the EB5, incidentally, which is something positive and which certainly can assist, is that if you're in the United States, again, for at least 90 days in valid status, you can apply for an EB5 and apply for the green card at the same time with interim work authorization, with travel for you and your family, and you can remain in the United States whilst this visa application is pending. So that really covers the employment-based visas. We've discussed more or less green cards in the various different categories: family-based, employment-based. Again, if you have any questions, please contact us, grant@gkaplanlaw.com. Telephone +1 561 347 8440. Talking briefly about consulates and waivers now. If you have some kind of an issue relating to your admissibility in the United States, for example, you may have a previous conviction, you may have previously overstayed, you may even have been ordered removed by the immigration court before, there may be waivers available to you. And I urge you to contact us and we can go through these and discuss these. That doesn't necessarily mean the death knell for your admission to the United States. We spend a lot of time doing waivers and various other ways to see how we can have you admitted to the United States. Of late, with the COVID vaccination requirements, we have a number of clients who either from a religious point of view or from a medical point of view do not or cannot have these vaccinations. And again, we certainly apply for waivers for them, and we have helped in certain circumstances. We also help with removal-based cases. If anyone is placed in removal hearings or they pick up a conviction in the United States and are placed in removal proceedings, we can certainly help with those as well. Again, we have a staff of 3 attorneys, 15 paralegals. We're available 24 hours a day. and we'll be looking forward to helping you guys. We've been around for more than 20 years. I was going to say 24, but I'm not as old as that. Please contact us, +1 561 347 8440, or email grant@gkaplanlaw.com. Our website, www.american-immigration-lawyer.com. We look forward to hearing from you.